It's Michael Popok, Legal AF, in anticipation of Friday's Judgment Day against Donald Trump in the civil fraud case, which could exceed $550 million with prejudgment interest. Donald Trump is telling anybody that'll listen, and I mean his social media followers, that he already won at the appellate court level, doesn't understand why he's here, thinks the judge had no right to conduct the trial or to decide whether Donald Trump is guilty of 5 more counts of persistent fraud, along with his organization and his executives. He's wrong. And let me just blow it apart here and put it back together again for you in this particular hot take. First, let me talk about what Donald Trump tells people in his social media posts. First, he tells them he won at the appellate court level, that he doesn't understand the trial even having started, that he thinks Judge Engoron has violated the appellate court's orders and directions, and that he will ultimately prove victorious. Let me blow that all apart. First of all, when Donald Trump lost, even before the trial started, at the summary judgment level, which means the judge, as a matter of law, without the need for a trial, determined that the New York Attorney General had carried her burden to prove without dispute that Donald Trump and his organization had violated a section of New York law 63-12, persistent fraud, and the power of the New York Attorney General to put persistently fraudulent businesses in New York out of business. The judge found that there was enough proof of that even without a trial. In fact, the judge even questioned at that time whether there was even need for a trial. He was ready to throw the book at Donald Trump, take all of his money, put him out of business, and ban him for life from the real estate and financial lending business without even a trial. But the New York Attorney General convinced the judge that she needed a trial in order to support, for appellate purposes, all of the remedies that she was seeking. And then they had an 11-week trial. During the course of that, Donald Trump appealed the motion for summary judgment granted against him. The appellate court, which the one that's in play right now is the First Department Appellate Division, which is the intermediary appellate court that sits over the New York State Supreme Court, which is trying the case. Don't be confused in New York. They say Supreme when other cities and other places call it Superior Court, but their Supreme Court is a trial level court. The appellate division is the one sits right above it for Manhattan. And then if you want a full appeal to the highest level court in New York, then you go to the Court of Appeals of New York. The appellate division court decided that they're going to hold off on, and they haven't ruled on the summary judgment issue yet, because they'll wait to see what Donald Trump does in terms of appealing the entire trial judgment that's about to come out on Friday. The only other ruling that the appellate division made was against Donald Trump. They've tried to dismiss the lawsuit early on, finding that, arguing Donald Trump's side, that a lot of the issues raised were time barred, meaning outside the statute of limitations. Well, the appellate division looked carefully at the record and set up a bright line to be applied by the trial judge and directed the trial judge to apply it. And what they said was, for certain of the defendants who entered into an agreement with the New York Attorney General, we call it a tolling agreement, which stops the clock on the statute of limitations for an agreed period of time. Why do defendants do that? Because they don't want the prosecutor or the attorney general to bring the case right away. They want to give the attorney general time to conduct the investigation and them time to convince the investigation personnel that they didn't do anything wrong. So you usually enter into a tolling agreement. In rare circumstances, strategically, you may not, but they didn't really apply here. So 2 groups of defendants, including Donald Trump, entered into 2 separate tolling agreements with Letitia James's New York Attorney General office. So one, the appellate division said, if any of the transactions, and there are over 200 misstatements of Donald Trump's assets on his personal financial statements that are at the heart of the civil fraud case, that he cooked the books on a statement of financial conditions more than 200 times. Some of those things, if they were for some of the defendants before 2014, then they can't be part of the case. Or for other defendants, if they were before 2016, they can't be part of the case. To put it another way, for a certain group of defendants, including Donald Trump, the transactions have to be 2014 and after. For others, it has to be 2016 and after. But there are plenty of transactions that fall into those 2 buckets under the 200 or more misstatements. So all the appellate division told the trial judge to do is use this razor and cut off claims and transactions based on the claims you're based on if it's before 2014 for some and before 2016 for others. But then, Judge, you got free run to run your trial. That's not a win for Donald Trump. Sure, there were some transactions that fell off the continuum and could not be used by Letitia James to calculate her disgorgement number. That's why the number is $370 million, not a much higher number because of this application of the limitations period. Doesn't mean she's not entitled to the 370 plus 9% compounded interest for almost 10 years. You do the math. We're approaching $750 million potentially at that point. So that was a loss, not a win for Donald Trump at the appellate level. By now, you may know I recently got married. See, we build up our lives with bright moments of joy, pride, and success. And however you define those moments, securing your future should be part of the journey. The things we build our future around are the things worth protecting. Making an estate plan now means gaining security of your assets and peace of mind for you and your loved ones. With Trust and Will, you can create and manage a custom estate plan starting at just $159. Go to trustandwill.com/legalaf for 10% off plus free document shipping. I know from my own experience that estate planning through other means can be an incredibly grueling process and often costing thousands of dollars. But Trust and Will makes it super simple and streamlines the entire process from A to Z. Trust and Will's website is incredibly easy to navigate, and the process is very straightforward. And one of the best parts is that after working with Trust and Will, you'll have a peace of mind that your assets and wishes are secure. Trust and Will has simplified the process by creating and managing your will or trust online, from finding out what's right for your family to finalizing documents with a notary. Ensure your family and loved ones avoid lengthy, expensive legal proceedings or the state deciding what happens to your assets. Trust and Will has made estate planning accessible and affordable. Live customer support is available through phone, chat, and email. Get the peace of mind you deserve by creating your estate plan with Trust and Will. Secure your assets and protect your loved ones with Trust and Will. Get 10% off plus free shipping of your estate plan documents by visiting trustandwill.com/legalaf. That's 10% off and free shipping at trustandwill.com/legalaf. Similarly, the only person that can claim with mild confidence and bravado that she won was Ivanka Trump. And Ivanka Trump, again, was not covered with any glory in the appellate decision. All they ruled was that all of any of the alleged fraud that she committed happened before 2014, and therefore, under her tolling agreement, she can't be sued for that. Doesn't mean she didn't commit the fraud. It just means the fraud is too old for the New York Attorney General to have gone after. I mean, look, it took the New York Attorney General a couple of years to get up and running. She had to get elected. Then she had to get her investigation up and running. She was working hand in glove with the Manhattan District Attorney's Office because they were doing a similar investigation on the criminal side. She was doing the civil side. So there were delays, honestly. I don't think she could have helped herself. I don't think she could have improved the amount of transactions that survived summary judgment, but it is what it is. So the only winner of appellate division decision-making is Ivanka Trump, not Don Jr., not Eric, not Alan Weisselberg, the CFO, not Jeff McConney, the controller, not Donald Trump. But he continues to tell people, anybody who will listen, because in order for you to understand what happened, you got to listen to a hot take like this that goes on for 10 or 15 minutes, or you have to read it yourself like I did. So that is, again, that's not a win at the appellate division for Donald Trump. And similarly, and a more of a loss because the appellate division gave Judge Engoron complete latitude of discretion as the trial judge to determine which transactions fell inside and outside of the relevant time periods. So look, the only other thing the appellate division did, at least one judge did, is they put a hold for now, and it's been put on ice, about whether Donald Trump's business certificates to operate his businesses are going to be dissolved. And all of his companies dissolved, the assets distributed by a receiver or a monitor. That issue, which is a remedy under 63-12 Executive Law of New York, if the New York Attorney General proves persistent fraud, even though there was a proof of persistent fraud in the summary judgment ruling, count 1, because there's 5 more counts that still needed to be adjudicated and decided by Engoron, the very proper and sober and judicious decision by the appellate division was, why don't we put a pin in the dissolution of the company, because once that egg is scrambled, we can't unscramble it. And let's wait until the end of the trial. Let's get all the fraud counts resolved. One way or the other, they'll all be against Donald Trump. Spoiler alert. Let's see what the final judgment looks like, and then do one big appeal at the end. You can appeal the summary judgment that should have been granted in Donald Trump's mind. You can appeal all the issues that you have about how the judge applied our ruling, the appellate division's ruling, about application of the tolling agreements and the statute of limitations. You can argue that some transactions were outside, some were inside if you're on the appellate side. Let's do all that at the end, and then we'll decide if you lose the appeal. Then we can decide, we can pull the pin and allow the disgorgement and the dissolution of the companies to go forward. That's all the appellate department did. They just put a temporary hold on it until the complete trial is over. Judge Engoron gets the chance to do his complete job all the way through the end, including issuing the judgment, and then they'll make their ultimate ruling. So I want you to have that knowledge as you hear, because there's going to be a lot of whipping information on Friday from various news sources, including here on Legal AF on the MeidasTouch network, about Friday. Friday's going to be a big red letter headline above the fold day. But I want you to sort of, in anticipation of it, these building blocks, I want you to kind of understand and dispatch some of these early attacks by Donald Trump about the appellate decision and disabuse anybody of any of this ridiculous, misstated legal analysis by a guy, Donald Trump, who misapprehends the law and mischaracterizes it any chance he gets for his own benefit. Let me make it simple to end this hot take. Donald Trump and the others are going to lose, and lose badly, on Friday. This judgment could come up between $500 and $750 million of disgorgement, and all of Donald Trump and his executives and family members banned and barred from ever serving as officers and directors in New York ever again. They won't be able to transact business with New York banks. Most banks are based in New York, and they won't be able to do real estate transactions in New York. That's a bad thing. We call that in our business the corporate death penalty. That'll be Friday. So this is what I want you to understand as a building block of analysis beforehand on this hot take. I do hot takes like this one about it. God, it seems like every hour, even on vacation, on Legal AF. And then on a podcast we call Legal AF. And the title means exactly what you think. It's every Wednesday and Saturday at 8 p.m. Eastern time. And then the leaders of Legal AF do hot takes like this one right here. Don't change that dial. The 2 million strong MeidasTouch network, soon to be 3 million with your free subscription. So if you like what I'm doing, leave me a thumbs up and a comment. It really does help with the ratings. Keeps us on the air. Until my next hot take, until my next Legal AF, this is Michael Popok reporting.
Love this video? Make sure you stay up to date on the latest breaking news and all things Meidas by signing up to the MeidasTouch newsletter at MeidasTouch.com/newsletter.